2022 CR 319 State versus Troy A. Tomlin Jr. All right. We have it set for.
Right off the bat, we're diving into a sentencing hearing with two big motions, and trust me, that's not typical. When a defendant tries to raise ineffective assistance of counsel and withdraw a guilty plea at the same time, that's courtroom fireworks. Buckle up, because this judge is about to walk a legal tightrope.
Sentencing, and I have two motions that have been filed in this case. One of them is a motion that the defense is alleging ineffective assistance of counsel. Then the other motion is a motion filed by the public defender, the attorney of record for the defendant, asking to withdraw the guilty plea. And first, let me ask Mr. Tomlin, you have the right to, allege that your lawyer has been ineffective in representing you. Typically, I want you to understand that typically that is an issue that is reserved for after all of your avenues of appeal have been exhausted.
Quick legal breakdown: claiming ineffective assistance of counsel before appeals are exhausted is like playing your trump card at the wrong time. The judge is warning him, say this now, and you may lose it forever. So the stakes? Extremely high. And you can already feel the judge trying to prevent Tomlin from torpedoing his own case.
In other words, you have the right to, ask to withdraw your guilty plea. I can rule on that. Then you can have an appeal of my decision. If I deny that, if I grant it, then obviously you're going to trial. And if you allege now that, and we hear your argument about ineffective assistance of counsel, then you are technically waiving that as an issue down the road to be raised on appeal. Do you understand that?
Sir.
All right. And then the second thing is, I have to consider whether or not there are grounds to allow you to withdraw your guilty plea. So that's the first issue that I'm going to have to address. And Mr. Howard is your attorney of record. And so I'm going to allow him to argue that on your behalf. And then if you want to be heard on that issue, then I will allow you to do so.
Yes, sir.
You keep raising your hand. What do you want to say?
I have a letter from the Good Wings boss. It states right here that she never worked at Good Wings, and he left his his information right here. And I have all the information right here stating that she was on a dating website. She never worked at Good Wings. And then on top of that, on that night, they arrested me for attributing to it to a minor, and then told me to stay away from the girl. And I did that, and told me to have no contact, no nothing. And then they come back and try to charge me again with the same girl. And I have all the police records, everything, and also I have the dating website what she's on, Your Honor.
All right, have a seat.
Okay, pause. This is a classic defendant data dump: letters, dating websites, contradictions, police reports, all thrown into the pot at once. But here's the catch: none of this matters unless it legally supports withdrawing a plea. And courts don't just undo pleas because someone brings new screenshots. The question is, does any of this actually meet the legal standard?
You are still technically representing this defendant, and you have filed a motion to withdraw his guilty plea. You, as I know, you and I both know that it's not an automatic thing. Can you tell me why I should grant such a motion?
Your Honor, at this point, I filed it upon the insistence of Mr. Tomlin. As you know, we entered a plea on, I believe it was September the 18th. I had discussed that fully with Mr. Tomlin. He met with me and Mr. Mitchell. We all discussed the evidence, the possible avenues. Thought we had come to an agreement that this was the best legal outcome for him. We did show up and enter the plea. I had no contact with Mr. Tomlin regarding this until 2 days ago when I filed this motion, when he called my office and said that he had decided that I was ineffective, that he would like to retain private counsel, and that he would like to withdraw his guilty plea and revisit the matter, Your Honor. Subsequently, I filed the motion to effect those wishes.
All right. Let me hear from the state about this.
Your Honor, the defendant pled in September
A subsequent judgment was submitted to the court and signed on September 18th, 2023. This motion was filed, these two motions were filed this week, way beyond 30 days of the entry of that judgment of conviction. Prior to a sentencing hearing.
And here comes the prosecutor, aka the courtroom's fact checker, ready to dismantle the timeline. When they start emphasizing dates and deadlines, that's usually code for, "Judge, this motion is legally doomed." Let's see how quickly they shut this down.
Judge, the court has discretion to withdraw a guilty plea for any fair and just reason. The court has gone on to describe several factors that the court can consider. The amount of time that elapsed between the plea and the motion to withdraw it. More than a month and a half has elapsed since that time. The presence of a valid reason for the failure to move for withdrawal earlier in the proceedings. There's really not an excuse why he would have not filed this motion much earlier in the process. Whether the defendant has asserted or maintained his innocence. This has been a best interest plea, Your Honor. The full terms of the agreement were not explicitly agreed to. However, most of a lot of the court is only here to decide whether Mr. Tomlin serves 2 to 4 years. So most of his sentence has been agreed to. It is understood by both sides that he will be on the sex offender registry for at least 10 years. That's out of the court's discretion. That's just mandatory due to these sentences. And distinctly, the exploitation of a minor charges, all sides know that is a to serve sentence at 100%. So the only thing the court is here to decide today is whether this defendant serves 2, 3, or 4 years at 100% TDOC. And both sides were made, have known that since the beginning. The court did a very thorough job at plea, making sure the defendant understood and making sure that nobody was forcing the defendant to take this plea. I rewatched it on YouTube yesterday. The statement of facts were given. He did not necessarily agree to them. However, this was a best interest plea. Circumstances underlying the entry of the guilty plea. Again, this is a best interest plea from the beginning, Your Honor. The defendant's nature and background. Your Honor, this defendant has a history with this court from the beginning of this case of leading everybody on. If the court will look to the file of his previous mental health, his competency evaluations, the first evaluation, the evaluator uses the key phrase malingering. And what does malingering mean? It means he's trying to lead on. He's not trying to give an authentic evaluation. And the court subsequently had to order a second evaluation to determine his competence. The degree to which
That word, malingering, is a nuclear term in court. It means the defendant may have been faking or exaggerating symptoms to manipulate the process. When a judge hears that, it absolutely poisons the credibility well. Every claim after this starts to look suspicious through that.
Which the defendant has had prior experience in the criminal justice system. His pre-sentence report will show that he does have a limited criminal history. This is not his first rodeo. He's been placed on probation before, at least with misdemeanors. The potential prejudice to the government and the motion to withdraw is granted. Your Honor, this is extremely important, not just the continuing leading on by this defendant and playing the system, but the harm it does to this victim. The pre-sentence report will be entered later at sentencing hearing, whether it happens today or at another court date, and it will show that the victim continues to suffer through depression, has had suicidal ideologies, has continued to seek therapy, and cannot even be at the courtroom today. It's too difficult for her to be at court. And the dragging on of this process, the allowing of this defendant to play this system, in and of itself, I think the court should deny this motion.
All right. First and foremost, the court would cite to the existing case law, which is pretty well clearly set forth in one of our Supreme Court Tennessee's decisions in State versus Crow, which is at 168 Southwest 3rd, 731. And it provides that a defendant does not have a unilateral right to withdraw a plea. Whether a defendant should be permitted to withdraw a plea is a matter addressed to the sound discretion of the trial court, regardless of when the motion is filed. The trial judge should always exercise his discretion with caution in refusing to set aside a plea of guilty to the end that one accused of crime may have a fair and impartial trial. When a constitutional violation is shown, the trial court's discretion is strictly curtailed. The trial court's decision will not be reversed unless it clearly appears there was an abuse of discretion. An abuse of discretion exists if the record lacks substantial evidence to support the trial court's conclusion. Based upon those factors, then, the court is of the opinion that if Mr. Tomlin wants to pursue his motion to withdraw his plea, there will have to be some evidence presented to this court to justify that. He can call your client to the stand and let him testify as to his reasons why he wants to withdraw his plea, and I'll make a decision based on whether or not there are sufficient grounds for doing so, Mr. Howard. Mr. Tomlin, you talk to your lawyer, and if you want to testify, we're going to allow you to come up and testify.
Yes, sir. Sure. Your Honor, the only issue I have with that is he's claiming ineffective assistance of counsel. So what's effectively going to happen is he's going to take the stand and claim that Mr. Howard didn't explain this to him, didn't explain that, and I can't call Mr. Howard as attorney to refute any of that.